All right, so today is one of my very favorite topics, and the topic is personal property. So gifts, bailments, lost and found property. So let's go ahead and get started. A gift between two living people is known as an inter vivos gift, and there are three elements of an inter vivos gift. This should be pretty much of a review for you. Those three elements are present donative intent. You intend to give someone something now. There must be delivery and acceptance of the gift. So present donative intent, delivery, and acceptance. I tell you that I'm going to give you a big flat screen TV for graduation. Is there present donative intent? No. Present donative intent, delivery, and acceptance. Another type of a gift that I think perhaps you should be aware of is a gift causa mortis. And a gift causa mortis is a kind of a conditional gift. Without being too morbid, I'll tell you that it's a conditional gift, that it's made when someone's on, when death is imminent and impending. And so it is automatically revoked if the donor does not die, if the donee dies before the donor, or if the donor expressly revokes the gift before death. So lost, mislaid, and abandoned property. So mislaid property is property that's intentionally placed somewhere. The owner or the caretaker of the location is to hold the property for the true owner. So let's say you're working cleaning hotel rooms in Virginia Beach this summer, and a guest is checked out, and you go into the room to clean it, and you see an emerald ring on the counter in the bathroom. Can you put it in your pocket and keep going? And the answer, of course, is no. You would give it to the manager of the hotel to be kept for the true owner. Lost property, you know it's lost by the place where you find it. And so let's say you're walking down Brock Commons and you see a $5 bill in the middle of the walkway. That's lost property. You can pick it up and put it in your pocket and keep going. The rule is what you think of, what you thought when you were a kid probably, and that is finders keepers. Unless you know who the true owner is, or can reasonably ascertain who true owner is, then you must return it to the true owner. And then, of course, abandoned property. The first person to exercise dominion and control over that property is the new owner. Bailments. A bailment is a transfer of possession of an item of personal property. There's no transfer of title, just transfer of possession. The elements will go through one by one, but they are possession, consent, and knowledge. Possession. A bailment does not exist unless the bailee obtains possession with the intent to exercise control over that item of personal property. For example, Joe went to the Seaview restaurant, and he hung his coat on a hook on the wall. And it was next to the door of the restaurant. He sat down and he ate dinner, and then on his way out of the restaurant, he realized that someone had taken his coat from the rack. Is the restaurant liable for the loss of Joe's coat? And the answer is, of course not, right? So bailment was never created because the Seaview did not have possession of Joe's coat. This would be different if there were a cloakroom and an attendant, right? But that's not what happened here. Possession, consent, and knowledge. Consent. A bailment is not created unless the bailee consents. Here's your example. Al bought new running shoes from the River Dogs. After wearing the shoes twice, they started to fall apart. So Al took the shoes back to the store to return them, and was told by a salesperson that the manager was out, that he would have to return at lunch, after lunch. Al said, "I'm going to leave the shoes here." The employee responded, "No, I can't be responsible for your shoes." Al left the shoes, and when he returned to speak to the manager, the shoes had been stolen. Is the store responsible for the loss of Al's shoes? And the answer would be no, because there was no consent. Possession, consent, and knowledge. Knowledge. Here's a case that's interesting. Again, the bailee must have knowledge of the bailed items for there to be a bailment. Real case, Ziva Jewelry versus Car Wash Headquarters. A salesman had $851,000 worth of jewelry in the trunk of his car. He wanted to have the car washed. So he went to a car wash and gave the keys to an attendant without telling him that the jewelry was in the trunk. So they didn't have knowledge that the jewelry was there. After the car went through the car wash tunnel, a thief who had been following the salesperson jumped into the car and stole it. The car was later recovered, but not the jewelry. Is the car wash liable? And the answer is no, because they had no knowledge of the $851,000 worth of jewelry in the trunk. All right, just in case you want to sit for the bar exam, what if the thief had stolen the spare tire in the trunk? Would the car wash have been responsible for the loss of the spare tire? And the answer is yes. There's imputed knowledge because almost all cars have a spare tire. Liability for damage to bailed property. The modern rule is this. We used to look to see what type of a bailment is this. The modern rule is this. When a bailment has been created, the person who is holding the property must take reasonable care of it. The bailee does have absolute liability for delivering the property to the wrong person. In this case, if you're interested and want to spend a little bit of time looking at this, in this case that I've cited on this slide, a valet gave a car to the wrong person, and a bailment was created. Is the valet, is the service responsible for misdelivery? And the answer is absolutely yes. And then let me mention one other time. I've mentioned this before, but liability of common carriers is based on strict liability. So if you ship goods with a common carrier, unless it's changed by contract, then they are absolutely liable for loss or damage to your goods. There are some exceptions to the rule, and that is if the goods were improperly packed on the part of the shipper, or an act of God. So let's say that the truck falls in a sinkhole on I-95 and disappears, or again, if there's some sort of a contract limitation in the shipping agreement. Last topic is intellectual property, which is a type of personal property. So let's finish up by talking about copyrights, trademarks, and patents. So copyright protects the rights of someone who has created a literary or artistic work. Registration of a copyright is permissive, not mandatory. In fact, it's the only type of intellectual property where registration is not mandatory. It protects literary, artistic, or musical works. It also protects expressions of ideas. So that would be computer hardware, computer software. They are also copyrightable. An individual's copyright lasts for the life of the creator plus 70 years. For a corporate or commercial copyright, it lasts for 95 years from the date of first publication or 120 years from the date of creation. Fair use, you may remember this from legal environment. Under certain circumstances, it is all right to use copyrighted work without the permission of the copyright holder. So if the copyright is being used in a parody or a satire, then you don't have to have the permission of the copyright holder. So that was the Two Live Crew case versus ACCT445 Music that we covered in legal environment. Roy Orbison had originally performed the Pretty Woman song, and Two Live Crew wanted to use or make a parody of the Pretty Woman song, and they called it Big Hairy Woman. Anyway, Two Live Crew asked to use it, and the copyright holder, ACCT445 Music, declined to allow them to make their parody. Two Live Crew went ahead and made it anyway. They were sued for copyright infringement. Was this copyright infringement? And the answer is no. You can also use copyrighted material for limited educational purposes or inclusion in a literary review or perhaps a news report without the permission of the copyright holder. Patent law is exclusively federal. To be patented, the invention must be useful, novel, and non-obvious. The item does not have to be mechanical, so computer software is patentable. Soybeans that were resistant to Roundup, those were patented. It's exclusively federal, registration is mandatory, and a patent lasts for 20 years. Trademark. A trademark must be distinctive. Trademarks protect against misuse. Colors may be trademarked in connection with a particular good or a particular service, and if a trademark becomes generic, then it loses all protection. So the classic example is Xerox. Xerox is so concerned that they will lose their trademark, a valuable property right that they hold, because people use the term Xerox improperly. So this ad says, if a trademark is misused, it could come undone. If you didn't know it, at one time Zipper was a valuable trademark, but it was misused, and the trademark holders did not stop others from misusing Zipper, and so it became generic, and then anyone could use it. So the last thing I'll mention is a trade secret. Trade secret could be a process, it could be a formula, it could be a compilation of information. It could even include computer hardware or software. To constitute a trade secret, it must be kept secret or guarded. It is a federal crime to use a trade secret. So for homework, I would like for you to do questions 1 through 6, question 12, 14, 17, 18, 20, 22, 26, 33, and 45 and 46. So that's the end of Module 33, and you have a good day.